So can you explain it to me like I'm 5 real quick?
No one's ever happy. Everybody hates you.
Yeah.
It's never fun.
Is it DBA?
So
A DBA is doing
gotta
business
think,
as.
right.
We thought that just because we had an LLC, we were protected, but I know that's not the case.
So we were talking about trust a little bit too. We do charge by the tortoise. So, they are more expensive than cats, but not as expensive as dogs or horses.
Someone as investors like us, where can we find all this information? This is interesting. I'm super intrigued now. I just want to say thank you because I was coming into a situation with this investor, helping him trying to clean up his portfolio, and you helped with a lot of it. So I appreciate that.
No problem.
And it was probably one of the most stressful times because dealing with evictions, it can be very crazy.
Oh, yeah.
But yeah, so let's talk about, can you tell everyone what you do? Like what's your...
So I have a law firm, Bone and Dresslove, with my partner, Mickey Bone, who's been doing this for about 40 years. I've been doing this for about 15. And together we don't really, evictions we do a lot of it. They're not our main focus. It's more on real estate, problems with buying houses, selling houses, problems with the title to houses or people trying to steal houses from you without you knowing it.
Wow.
We do bankruptcy, as far as debtor and creditor work. So if you owe a lot of money, we can represent you. If you somebody that owes you money files bankruptcy, we can represent you in that instance as well. And then we do, the third major area is wills, trusts, and estates and probates. So estate planning for later on in life, and then in the opposite or in the alternative, dealing with what happens with the lack of an estate plan after you pass away. So those three major areas, and of course evictions are part of the real estate, but actually don't make up a ton of what we do.
Wow.
Just in your case, we have a lot of them.
What's your favorite practice to do?
I like doing it all. The nice thing about, having your own company is if you don't want to take a client or you don't want to do an area of practice, you don't have to.
Yeah.
So I only do the things that I like.
Oh, nice.
So, things that we avoid, like the plague, are family law. People call us and say, hey, I need this problem. Sorry. We don't do family work. No, no one's ever happy. Everybody hates you.
Yeah.
It's never fun. And then criminal defense. We've never really gotten into that. Personal injury. You see them all over the billboards.
Yeah.
We're not set up for that. To do that, you need to have you need to be ready to basically work for months and months and months without any kind of income. And if you win, wonderful, you get paid. But we don't do that. We let the billboard attorneys fight over all those cases. What we do is a lot of procedural stuff and a lot of litigation with regard to real estate and bankruptcy.
Oh, wow. That's cool.
Yeah. Not exciting, but it's fun.
No, it's interesting because there's a lot of people out there that, they look at law or real estate and they want to make sure you're doing everything correctly, but it's just like they don't know who to go to or who to turn to. So that's why I'm glad you're here because even though we have a small following, maybe you'll get some kind of business from all our people,
Sure. Hey, that's what we're here for.
Yeah. So the best way to structure our LLCs is pretty much you recommend doing a series, correct?
Correct. So if you are in Nevada and you have property in Nevada,
Yeah.
And you have renters or you have people that you don't control or that aren't family that are in these properties, then you have liability. If something were to happen to someone in that house and they sue you, it doesn't necessarily mean that they're going to win, but if they do win and they get what's called a judgment or an order against you, they can reduce that to a lien against any of your properties. So even if you have everything in your name or in one company and they get a judgment against you, they can attach that judgment to pretty much everything you own. So the idea is to separate everything into different entities. So if something happens and for whatever reason you do end up with a judgment against you in you company one, LLC number one, well, then all that person's going to be able to come after is what's in LLC one. So if you have 7 houses and each one of them is its own LLC, they're all protected. And the same thing for outside protection, meaning if you guys in your personal lives incur some kind of liability and you have a judgment against you, but all your property is in separate LLCs, nobody can touch what's in the LLCs, only what's yours personally. So by separating everything, you create a much more difficult situation for anybody to collect from you.
Gotcha.
And then we were talking about the trust.
Yeah.
And the only reason, I mean, there's a couple different types. I won't get too in depth, but the main reason people put an LLC into a trust is that the purpose of a trust is for transferring property when you pass away. So by putting the LLCs in the trust, or what you do is you make the trustee, the member, manager, or owner of the LLC, then whenever that person passes away, there's what's called a successor trustee that jumps in. So you don't have to transfer property, you don't have to sell anything. That person that comes after you pass away just takes over and keeps running the business or doing whatever you wanted them to do pursuant to the trust.
Yeah.
So there are things called a spendthrift trust or an asset protection trust. That's a whole different animal. And that's for if you have a kind of business that's prone to a lot of liability. What that does is that will take all your assets away from you. You will no longer own them. Basically, you'll just be a tenant in your houses. You'll have nothing to do with them, and because of that, because you don't own it, nobody can attach it. But the reality is that you still gain all the profit from it. You still run the companies, but somebody else technically owns it.
Okay, so can you explain it to me like I'm 5, real quick?
Sure.
So there's a trust, or actually,
Well, you're talking about
explain it.
two different things.
Explain it to me like you're explaining it to Gina, to me. So you have to like.
So do you want to talk about LLCs or
Or
trusts?
no, okay, so there's a trust and then an LLC, right?
Yeah,
underneath?
they're not underneath. They're
okay.
two separate things.
Separate, okay.
So, and again, you don't have to have a trust be the owner of the LLC. Most people don't do that. You can change it later on and add it, but
Yeah.
most people just have themselves.
Okay.
So, or whoever, another company, but the LLC is a limited liability company. You can form them in every state. Nevada has what's called a series LLC, which is one of only 8 states that does. And instead of having to set up, let's say you have 7 properties and you want to protect them all. Well,
Yeah.
you can get insurance, and that always works great, but it's always better to put them in separate LLCs, or separate companies, to kind of create that divide, that separation. And you can do that in most states, but you're going to pay what's the yearly Secretary of State fee
Yeah.
of $300, $400, $500, depending on where you are, per LLC. So if you have 7 LLCs, 8, 9, 10, it adds up.
Yeah.
Pretty soon you're paying thousands of dollars a year. A series LLC provides the same exact protection, but you only pay 1 Secretary of State fee.
Okay.
So that's the main difference. You save a lot of money every year.
Okay, so the series has all the 7 different properties.
Think of it like
so
a tree.
Is it DBA? Is that
Well,
what it is?
So that's part of it. So
A DBA is doing
you got to
business
think
as.
right, correct. So you think of a series LLC as like a tree. So the main LLC would be the top of the tree, and then or the base,
Okay,
and then the branches kind of spread out, and each branch is its own LLC.
gotcha.
But they're not set up as their own. They're set up as part of this main LLC, but they still have all the same protections of a regular LLC.
Okay.
So instead of having 7 trees, you have 1 tree with
Gotcha.
separate little parts to it, but it works the same way. You get the same protections. And the benefit is you only pay 1 Secretary of State fee, not
Yearly.
not 7, 8, 9, whatever it may
Okay.
be.
Wow.
Now, so yeah, that's the benefit. There's no other benefit other than you're literally saving money.
Yeah.
Other
So-
than that, it's the same.
I do have a question. So we have multiple different types of businesses. Can you have one LLC with different? For instance, like our main LLC has a series, and then we have a few properties in there, and then we have co-host ninjas. Can I do that? And then I have Dream Big Frenchies.
You can separate anything out as much as you want, or you can have everything together. You can have one LLC doing multiple businesses or multiple avenues of profit. There's no rule that says what you can or can't do. So if you want to have, what was it called? Something ninjas?
Oh, co-host ninjas.
So if you want to have co-host ninjas, doing, the renting of properties, but also, doing classes on how to rent properties, it can do whatever you want.
Yeah.
So again, it's up to you how much separation you want. So you can set them up as a separate LLC. You can set them up as the same. It's just whatever ease of use,
Okay.
So there's no rule against either way.
Yeah.
So about LLCs, I know a lot of people think, like ourselves too, that we thought that just because we had an LLC, we were protected. but I know that's not the case. Can you go over some things that
Sure.
may pierce
There you
the
go.
corporate?
Good term of art. So yeah, piercing the corporate veil. So just having an LLC alone, well, it creates a little more of a hill for someone to get over to get your assets. It's not this impenetrable fortress or barrier or force field. You have to maintain it. So the first part of that is you have to have a valid LLC that's licensed and maintained with the Secretary of State of Nevada, and that means every year you have to complete your corporate formalities. So you have to file a renewed articles of incorporation with the state of Nevada. You got to pay the fees, but beyond that, you have to keep formalities with how you run the business, because this is, after all, a business, a company, a corporation, almost just like the same thing as if you were running your own company with 500 employees. So as board of director members, you're going to have to, in part of the operating agreement, you set up who's the board of directors, the president, the secretary, the treasurer. It can be all you guys. It can be Scott, or Gina. But part of that is that you have to have meetings at least once a quarter, saying, hey, we're meeting, we're talking about profits, losses, we're talking about what we can and can't do, why we're not making money, why we are making money, what we have to focus on. And you make notes on those meetings. A bigger aspect is going to be commingling of funds. So you don't want to do that. You want to have each LLC have its own bank account, and you can do that. You get an EIN very easily from the IRS, and then you can use that to open up bank accounts. Now you keep them separate. So if you have, LLC 1 is making a certain amount of money from rental income or from whatever it might be, you can't just take that money and use it to pay your car payment, your cell phone bill, your mortgage on a different house, your credit card bills from your personal credit cards. You need to basically make a distribution at your quarterly meetings or monthly meetings. You say, hey, we made this much money, and because our operating agreement says we can give our money to ourselves, we're going to choose to distribute X amount of dollars to ourselves, and then you transfer that as a distribution into your main bank account.
Wow.
And from there, you can use that money to, pay your bills. But you can't commingle, because there's a problem called alter ego at that point. The argument's going to be that, hey, you and the LLC are the same. And because you're the same, why should the LLC be able to protect you? It's just a fraud.
Yeah.
Because there's no real LLC. You're just using the assets just like your own.
Yeah.
So you have to have corporate formalities. You have to maintain a distance. You have to have separate bank accounts. You can't use corporate funds to pay personal bills and vice versa. You have to have the meetings. There's a few other things that have to happen, but that's the main gist of it. And then beyond that, you just want to make sure that you pay taxes. Some people use them as a pass-through, meaning that all the profits will flow straight through to you, and you just pay your personal taxes. Other people set it up like a corporation where the LLC will have its own tax base. So you want to treat it like a real business, and if you do, you'll be fine. Now, I don't know how complicated you want to get in here, but
Yeah.
in Nevada is a great state for LLCs, because if someone gets a judgment against you personally and you own an LLC or 7, since we're using that number a lot, at that point, they can basically do nothing. They can sit. In other states, they can get charging orders to say, what that means is, hey, whatever profit is due to you from the LLC, we can force you to give that to us. Not Nevada. So in Nevada, they can basically just sit, and if you distribute money from that LLC to you, they can take it. But as long as you don't distribute anything, they don't get paid. They'll have to wait for years and years, and that's it. In bankruptcy, it's a different story. So if they do sue you and somehow they get a judgment against you, this person that now you owe money to, and you have a job or you have other assets that you can't protect, and so you file bankruptcy to protect those, well, now you have a problem, because in bankruptcy, the LLC won't shield you. So because the asset is owned by you and whatever your interest is, let's say you're a 50% owner of all these LLCs. So that means you have a 50% interest in all of the profit and the equity and the assets of the LLC. The bankruptcy court can go in and take all that. They can take control of it, and they can force you to sell it and pay off your creditor. So that's the downside. It will protect you from a lot of civil lawsuits at the state level, and it will not protect you from bankruptcy, meaning you won't be able to get bankruptcy help. You won't be able to file, because if you do, you're probably going to lose the LLC. So other than that, they're great because what we're talking about now, we're getting more extreme and also more very particular situations. But for the most part, yeah, they will be able to protect you from most of the problems that will pop up. So we were talking about trust a little bit too.
Yeah.
Now, do you want to talk about trust? or
Yeah,
no?
please.
Well, I was gonna ask, like, so you mentioned the trust being able to be passed down after somebody passes, but what about for people with wills? What happens to their property when they
I thought you
pass?
said people with wheels. I'm like, well, if we're talking about disabled people, they can't do trusts. No. So people with wills. Yeah, so let's put LLC to the side for a minute. And now we're looking at a trust. The main point of a trust is to avoid probate. In other words, probate is a court process where if you don't have a trust, you have to transfer your property after you pass away. Well, the only way to transfer property is by signing a deed to the house, signing a title to your car. Well, you can't do that if you passed away. So the court has to step in and do it for you. And that's the probate process. The downside is it's very expensive and it's time consuming. It can take between 6 months and a year, depending on how many objections there are and how complicated it is, by how much stuff you have to give.
Yeah.
So to avoid that, you set up a trust before you pass away. It doesn't have to be right before. You can do it anytime. And you can always amend it. So you can change it. But the way the trust works is you meet with an attorney. You tell them what you want. There's a will that's part of it. So for anything that's like that's deeded or titled, like your car, you got a title to your car, or the house, you have a deed. That's all going to be part of the trust. Meaning
Gotcha.
you have to fund the trust. You have to basically sell all of that to the trust. So you sell your house to the trust. You sell your car to the trust. And you are in control of the trust. So basically you're selling it to yourself,
Okay.
but in the name of the trust. And by doing that, what you specify in the trust is that, hey, when I pass away, the trust will survive and somebody else will stand up in my place. It can be your son. It can be a friend. It can be a company that is hired just for this purpose. And at that point, because they haven't passed away, they're still there to sign all the documents. They can just go ahead and transfer all the title to the house, the car, whatever they need within days or weeks, without the court, without anything. So it's much more efficient, and it's going to save your people, your heirs or your beneficiaries, the people that you're giving your stuff to. It's going to save them thousands of dollars. I mean, the average probate's $10,000 minimum.
Wow.
So mostly, there's exceptions, but that's probably about average. As part of the trust, you have a will. And most wills will say, I want my diamond ring to go to Bill. I want, the painting on the wall that everybody hates to go to Sarah. Stuff like that. So the will in a trust is a little different. It's called a pour-over will. And all it's going to do is give everything you own that's not deeded or titled, all your personal property, the kitchen table, the couch, the photo albums, the computer, all of that stuff will then become property of the trust. It'll say, on my passing, the trust gets everything. And that way, the trustee who steps in after you pass away, called the successor trustee, they can then distribute pursuant to the trust, because you're going to say in the trust how you want everything to go.
Yeah.
And so they will, their job, their only job, is to make sure that what you want happens. So if you say, I want my diamond ring to go to Bill, well, the trust is going to say that, he gives it to Bill. If you want the property sold and all the profits, put into a bank account and split up, they can do that. It's whatever you want. And that's the point of the trust, is that your wishes are met, but you don't have to go through the court to do it.
Gotcha.
And then the other nice thing is with a will, which you can do as well. If you don't have a house, you don't have a car, or you don't have anything to worry about probating, you don't need a trust. A will's just fine. But making changes to the will is a bit difficult, because you have to have the same level of formality as the original will. So basically, any change to a will has to be its own will. So you have to have two witnesses that witness you signing it. They have to be notarized, saying that they were here. It's a whole process. But with a trust, you can amend it very easily with just a one-page amendment that's notarized by you. You stick it at the back of the trust, and that becomes valid. So
Okay.
you can always change it much easier.
I have like 5 tortoises, and I've been told that we're supposed to put them in a will because they outlive us.
They do live a long time.
Yeah. So since we have 5, are we supposed? Does it cost extra to add another tortoise in there, or how does that work? Or is it one set price?
You keep getting
Well,
tortoises,
we do charge by the tortoise. So, they are more expensive than cats, but not as expensive as dogs or horses. No, it's the way it works is that in the trust, and unfortunately in Nevada and most states, pets are personal property. So the way it's set up now is you would just put in the trust just like the diamond ring with an addendum or an add-on basically called a trust personal property addendum. And that's going to list all the personal property you want to give to people.
Okay.
And so with the tortoise, you could say, hey, I want, tortoise 1 to go here, tortoise 2 to go there. Or in the alternative, you want them all together and you want to set aside money for their care, you would set up, a trustee just for the care of the tortoises. And we'd incorporate that. The part of what we do is basically listen to what you want and make sure the document, the trust has all of that in there. And then in that specific trust, it would be what's called a discretionary care trust for the care of, usually it's for people, but for the tortoises in this case. So, or the dogs, or, or your son, or whatever it might be. But there would be a separate trustee for that. It can be, your mom or someone you really trust or care. And then you talk them beforehand to make sure they're okay with it. And then they basically take the tortoises. You leave them a chunk of the money in that trust. And then they take care of the tortoises for the rest of their lives or whatever, you want them to do.
So if somebody has a primary residence, they have a conventional mortgage, would you recommend them putting that property into a trust?
I always recommend putting properties into a trust. Even if you have a home and you live there and you're not renting it out, there's no real liability. There's no need for an LLC at that point. It's always good to put in trust because, again, nobody plans on passing away. A trust isn't going to hurt you. It doesn't affect your tax base. It doesn't affect your property tax level. You don't have to reassess anything. You literally transfer it from you to you as trustee of the trust. The transfer itself is not subject to any property transfer tax. It's an exemption. So it doesn't cost you anything extra other than the cost to draft a trust or have the attorney, if you want to use an attorney, go through and make sure everything is hunky-dory and get everything signed up. But that being said, you never know. Like right now, if you have a house in your name and you pass away, well, the court is going to have to come in and step in and take care of that unless you have a joint tenancy. So if you're married and you hold title as, or even if you're not married, but if you hold title as what's called, it's a very specific term of art, joint tenants with right of survivorship, then you don't need to probate it. Because let's say you guys were joint tenants with right of survivorship, that means that if one of you passes away, whoever survives takes that other person's share without having to go through court or anything. So in that case, you wouldn't need a trust. But in most cases, or if you don't have that, a trust will keep you out of probate. So you might be, flying next week somewhere and something happens. You don't plan for that. But if the house is not in the trust and you're not a joint tenant, or married with joint tenancy, then whoever's taken that house is going to have to go through probate, and it's going to take a very long time. It complicates matters because let's say the house is just in your name, but and now you want to transfer it, but the mortgage is in your name too. So this is where the trust comes in as well and talks about what you want to happen with that mortgage. Do you want the house sold and the funds from the sale to pay off the mortgage, and then the equity goes to pay your beneficiaries? Do you want to keep the house? And if you had an older kid or an older sibling or somebody who was an adult, and you want them to take the house, do you want them to take the house subject to the mortgage, meaning having to pay it? Or do you want to use all the assets from your other stuff that you sell, all the tortoises that are worth a lot of money, so you sell them? Do you want to pay off the mortgage with the tortoise money? So all this stuff is in the trust. It gets very complicated. Most trusts, if you're done right, are hundreds of pages for a reason, because they want to cover every little thing that can happen, because you don't want any ambiguity. Ambiguity is where lawyers live. It's a gray area. So if you have no gray area, then you're good to go. And most trusts and most wills are handled or administered without a problem. But some, you get siblings that fight over the money. The more money, the more problems. So if you have an estate worth millions of bucks and you got like 3 or 4 kids, well, unfortunately, there's probably going to be a lot of fighting and attorneys. And so what your job is before you pass away is to basically set up as straightforward as possible exactly what you want to happen, to the point where you have even weird scenarios in there that might never happen, but if they do, they're covered in that trust.
Yeah.
So now the way it works with an LLC is you then have the owner of that trust, the trustee of that trust. While you're alive, it's you. And then after you, the person who comes after, who's in the trust, it says who comes after the successor trustee, that person is the person who's the manager of the businesses. And you run the businesses like normal. Now, the taxes for the businesses are still taxed through you. even though, it's the trust, you're the one paying the taxes on it. Because again, the trust is not a money-making entity. It's just a holding entity for property and for cars and for whatever you want to do. But that's pretty much it. But yeah, I would always recommend if you have real property, you need to file a homestead exemption, number one.
That's right. We got to do that.
Yep. Because if you don't and something happens and there's creditors, they can come after you and take the house. In Nevada, you get a whopping $605,000 in equity to exempt first, meaning if you have a house and somebody sues you personally and you have the homestead that you've recorded against your house, at that point, the first $600,000 in equity is not collectible. So if you only have $300,000 in equity on a house, and somebody wants to take the house, well, they're not going to because they're going to have to pay the cost of the sale and realtors, and then they're going to have to give all that profit to you. So no one's going to do it.
Yeah.
So that protects you. If you don't have that and you don't fill it out and you don't record it against the house, and you die, something happens to you, and then somebody comes after the estate, well, there's no. Well, at that point, it's a whole different story. But you want to go ahead and it's a one-page document. It's very easy to record.
Yeah.
And it protects you personally from liability. No one will be able to touch your house. If you have more than $600,000 in equity, well, congratulations. you're not going to be able to save it. You need to put it in LLC at that point.
Yeah. One day our live and flip now will be 600,000
Hopefully.
in equity.
So putting a property, your personal property, into a trust that doesn't do anything with the lender, where
No.
they try to accelerate the loan, or
Almost every loan is allowed. You're allowed to transfer it into a trust and out of a trust, as long as you are the trustee. You cannot put it in a spendthrift trust I discussed earlier, which is a trust to protect you from creditors, because you don't own it anymore. It's whoever the trustee is. So you're totally fine. You're allowed to do that. What you can't do, most mortgages will not allow you to transfer the property to anybody else. So that becomes a big problem, theoretically a big problem, when you want to transfer property by in your own name to an LLC when you have a mortgage, because technically that violates the mortgage and could trigger acceleration or foreclosure, where they send you a nice letter saying, hey, congratulations on starting the LLC. You have 30 days to pay us $497,000 or we're taking your house.
Wow.
So to put that into perspective, in 15 years of doing this, I have never seen that happen where someone is making on-time payments. However, very recently, within the last month, actually, I did see a complaint for the first time where somebody stopped making payments after it had already been transferred, and they have sued him, and part of the lawsuit is for breach of that contract, for saying, hey, you're not allowed to do this, that's a default. So even if there's any argument regarding, how much money do I owe, should I modify this? This is a separate argument. The bank's coming after saying, well, no, you breached the contract. We don't care about money anymore. We want the house, period. So you don't want to risk it. I mean, it's what you get into when I have clients and I tell them, hey, there's a very tiny possibility that this could happen. And, if it ever did, I'm sure putting it back in your name would probably satisfy the bank. But the reality is that I have never seen a bank take a look in that direction as long as they're getting money. As long as they're getting paid, the bank's usually like a sleeping giant. They don't care. It's only when something comes up and then there's a problem that they kind of review the documents, go, wait a second, this house is owned by Gina, not by the LLC. We never gave her permission to do that. So,
Yeah.
but again, and like I said, one lawsuit in as many years, it's very rare. And when I say the bank probably would be okay putting you back in your name, I say probably because, again, I've never had a case like that.
Yeah.
So I wouldn't know. But I'm guessing they probably would be okay because most banks don't want to foreclose on houses. It costs them a lot of money. Usually they're losing a lot of payment. And then the cost to sell again, they're selling at a discount. They're probably losing a lot of money. Or if it sells at foreclosure, they're making some back, but not everything they would have made if it had gone through, the full life of a 30-year fixed loan, which they would have made a lot more profit.
Okay, so I know that you're heavily into real estate and you do probates and stuff like that. So where someone as investors like us, where can we find all this information?
For probate,
Or any kind of pre-foreclosures? I don't know if you work with those kind of clients or...
we do. So we do foreclosures and foreclosure defenses. A foreclosure only becomes public when the bank files what's called a notice of default, breach, and election to sell. That means, hey, at that point, we're starting the foreclosure process. And then, if you don't do anything within 120 days, you will not own your house anymore. Now, there are defenses there. State of Nevada has a foreclosure mediation program, which you can sign up for. You basically petition for it to the court, and you can do that within 30 days of the lender filing that same notice, that notice of default. After that, you can't do it.
Yeah.
You can file bankruptcy. In a Chapter 13 bankruptcy, that's a repayment bankruptcy. That's where you basically work with the court, with the bankruptcy court, to set up a payment plan to cover all your arrears. It's really difficult, and most people really can't do it because it involves paying back everything that you owe that's late
Yeah.
while making current payments. But if you can do it, the bankruptcy court can protect you, and you have 5 years of not having to worry about being sued by anybody else, and you can kind of catch
Yeah.
up and make the payments on your house. And then, of course, there's, you can sue in district court in Clark County if you're here, and you can basically petition for time to say, hey, I'm going to sell my house. I got all the equity I need. I'm going to pay everyone off in full. And, you seek a restraining order to stop them from the foreclosure, giving you time to sell your house.
Okay.
But that being said, if you're not making payments, that's what's going to happen.
Yeah.
But if in the alternative, you own property and you have a person there who owns it, if you own property, you own a note. If you own the deed, you own the money, the beneficial interest in collecting on that note that's due on the house. Somebody doesn't pay, then you foreclose, and it's the other side. Now you have to, go through and try and make sure that as quick as possible you get the house back. But a foreclosure process is not like an eviction; it can take years.
I was just curious from like an investor standpoint, how can we help them stop the foreclosure process? Because we've had a few instances where we're trying to stop that so we could help the homeowners.
So I've talked to people who have wanted to do that as well. And getting back to your notice question, while yes, when they record the notice of default, that's recorded, but there's no database of notices of default. It's just there. And if you search the APN number, which is how you find properties online, you'll see it. There's two real ways to search for properties, one for probate and one for foreclosures. And that's only after the second notice is recorded, which is called notice of trustees sale. And that's where it's set up. They have to publish that. So they publish that locally, at least, in a magazine called Nevada Legal News.
That's what it is.
Yep.
I can remember you telling us. Okay, so Nevada Legal News.
Yep, and
okay.
you go and get a subscription to that, and every issue of that, they have all of the new foreclosures listed, the addresses. You can go through them and see. A lot of people are trying to sell houses as well, so the other way to do it, and for probate, is through the MLS. So you can look for houses that are in probate.
Yeah.
I'm not a realtor, but my realtor has searched for probate sales, so I know there's a way you can probably put a keyword probate or something.
Yeah.
And you can also look for foreclosure. A lot of those will say pre-foreclosure or in foreclosure. And at that point, you can go back and work with the bank. The downsides, you can buy foreclosures too if you're trying to flip. The downside is if you're buying it on, let's say, a first that's been defaulted and there's also a second, or you're buying on a second and there's also a first, all you're doing is paying off. If you pay off the first, the second goes away. If you pay off the second, meaning, so let's say, let me clarify real quick. If you're buying a foreclosure, and because they defaulted on their second loans, the first mortgage and the second mortgage, they haven't paid the second, so the second's foreclosing. The first is going to survive. So when you buy that house, you're buying it assuming the first.
Okay.
But you don't know how much that is. All you get to see is what that first was 10 years ago when they got it. You don't know if they've made all the payments or if they haven't made a payment, they just haven't foreclosed. So it's a risk. So you can get that house for a discount, but you need to look at
Is it like a
the
quick
possibility.
title? Is it a quick title search?
A quick
to
claim.
see?
Oh,
A quick title search?
it's not a title search. So you can go to the Clark County Recorder's website, and you can put in the APN number of the property you want to look at, and it'll give you a list of every document that's been recorded. It won't show you the documents. You're going to have someone with a title or escrow company or a realtor that has contacts that you can reach out to. They can give you those documents, but you can see what documents are there. So, and it'll show you, like, if they got a mortgage in 2006 for $150,000, it'll say way back in the list, deed $150,000. So you can see, or deed of trust $150,000. But you don't know. Maybe they modified that. Maybe they never made payments on it, and now you have another $300,000 in default interest rate. Maybe it's a hard money loan.
Yeah.
Again, you can get those documents and look at them, but you don't know where they are now. So there's a risk that you might buy a house with absolutely no equity and you're upside down. In the alternative, if there's only one loan, you want to make sure there's no liens on it. There are no lawsuits, no judgments from from like Republic Services can have liens for thousands of dollars because they don't stop trash service even if you don't pay. They have to keep going, so they put liens on properties. So you want to do that. Check with the recorder's office, kind of get an idea what's going on. It'll help you. And the other problem is that you don't know what the condition is inside of the house. You can look at the outside. You can look at photos of the outside, but inside you don't know if it's been trashed.
Yeah.
So you buy with this in mind. You want to give yourself extra wiggle room just in case you got to spend $50,000 to rehab it. Or in the alternative, you find out that there's another mortgage or another note or another lien against the property, which you didn't know about. If you're buying a house and you know there's a first on it and you're buying the second, and you know that, okay, the first was for $150,000 again, and there's only going to be like $190,000 equity, it's probably not a good purchase, because I can tell you there's going to be a lot of unpaid interest and probably principal in the first as well as the cost to go in and repair the house, repair damages, bring up to something you want to be able to sell. As far as make a profit, it's not going to happen. So you need to be careful. You need to be able to look and say, okay, I would say I would advise staying away from any house where you're buying a second and there's a first. If you're buying the first, then everything goes away. Everything below that is junior that goes away.
Can you explain first and second again real
Sure.
quick? Just
First is like the original, right?
Correct.
Original
Yeah,
line?
it goes
Second would be
goes
like
by time. So the first recorded deed or document is going to be the first priority. So you have the purchase money mortgage is the first. Let's say they bought it, the house, they got the loan same time. And then you have a second, which is subordinate to the first. That means that it came in later. So maybe a
like
week.
another loan?
Yeah, like a second mortgage. So some people get two different kinds of mortgages at the same time.
Okay.
But let's say the first mortgage is the main mortgage. It's a conventional, let's say 30-year fixed.
Okay, I get it.
And then they also get, let's
Like
say,
a HELOC or something?
like a HELOC
Okay.
later on, or any kind of second.
Cash out refi?
All of that, yeah.
Okay.
All of that would be subordinate, meaning so whichever number of loan or position loan forecloses, everything later than that goes away. It's wiped out. So if there's, let's say they have 4 mortgages, they wiped out. There's no equity here.
Yeah.
So, and the second mortgage of the 4, it forecloses. They haven't paid, they foreclose, it goes to sale, it
Gotcha.
sells. So
Okay.
now the second is paid. They went to foreclosure. Theoretically, it sold, they got paid. Let's say there's a little bit extra money, that goes to the next in line, the third, and then the rest of the third is wiped out, and the rest of the fourth is wiped out. But the first, anything older, will survive. So if you're buying a second, third, or fourth mortgage, everything that predates that survives, and they can come after you and take the property back from you. You buy the house subject to that loan or that mortgage or that lien, and you need to make sure that when you do that, that you have enough equity to be able to say that, because to pay the mortgage off from the proceeds of a sale if you flip it, because otherwise you're stuck holding the ball, and they're going to foreclose against you, and you've just lost your complete investment at that point.
Yeah.
So I would say, be very careful if you're buying anything that has a superior loan to it on the property. Again, you can look at that by just going down the recorder's list of documents, and you just look at deed of trust. Okay, here's a deed of trust from 2020. Here's a deed of trust from 2015. Okay, this 2015 one is the one that's foreclosing. Let's go back and look and see maybe there's an earlier one. And you want to look from when they purchased the property and then go forward from there. Most times when someone buys a property, like 99% of the time, the previous deeds of trust, the mortgages are paid off in the sale. Sometimes they're not. So, it's always good to have somebody who knows what they're doing look at that and just make sure that, hey, there's no random deed here from 2006 that never was, paid off. So
Okay.
that might come back to bite you in the butt later too.
That makes sense.
You're kind of you're jumping into a problem. You're basically
Yeah.
you're buying somebody else's headache.
Yeah.
So you want to make sure that from that headache, there's nothing that's going to surprise you.
Okay.
And if you can do that and make some money, great.
Yeah.
If you can do that and you don't have you're really tight on the budget, well, if it works out, wonderful. But if there's a problem that pops up, there goes your equity.
Yeah.
So in most cases, you can check all this, like I said, in the Clark County Recorder's page. You can go to the Clark County Assessor and see the current owner.
Okay.
You can get a lot of information that way. And then, but if you're buying a house with just one mortgage, that's probably going to be safer, because they set up for what's called a credit bid, meaning when they go to auction for the foreclosure sale, they set a minimum, and that minimum price is what's going to be to pay them off. They can set it to less than that if they think there's not enough equity, but
Yeah.
most of them set it to that minimum. So if there's with the foreclosure costs and attorney's fees and the late fees and penalties and all the excess principal due, and let's say it's 186, well, they're going to put it for 186,000, and you buy it. Let's say nobody else bids, you buy it for that.
Yeah.
And you think the house is worth 300, so you got a lot of wiggle room. Well, you know that it's going to wipe out every newer loan after that. So you're basically taking the house free and clear at that point. You're paying cash for it because when you go to foreclosure sale, you have to pay right
All
then and
cash,
there.
yeah.
And it's not cash, but it's cashier's
Yeah,
check,
yeah.
or you have to have form of payment
Yeah,
there.
yeah, yeah.
I've never seen somebody bring a big bucket of cash to like a foreclosure sale, but I guess it's theoretically possible.
We'll make it happen one day.
Yeah, right. Well, you're downtown Las Vegas in a not nice neighborhood usually, so you do that at your own risk. But that being said, if you were to buy that property that has that equity, then okay, now the risk is not necessarily that you're going to have this surprise loan jump up and bite you in the butt. Now it's going to be okay. Well, what's the condition of the property? And sometimes you get in and it's great, and you just made a buttload of money. Other times you get in, you're like, oh my God, like it's literally stripped down to the studs.
Yeah.
And that's the risk.
Yeah.
You can go and you can peek in the window. You can't go, into the house. It's trespassing at that point. You don't own
Yeah.
it. And maybe people still live there. That's the other downside we didn't talk about is when you buy a foreclosure, well, the people usually still live there. And now they become your problem. And there's two ways that you can handle that. So before we talked about summary eviction. Well, you can't use summary eviction against a former owner from a foreclosure sale. You have to do what's called a formal eviction, which means you actually have to sue them in court,
Wow.
serve them. You've been served, hand
Yeah.
them papers, and you're suing them for what's called a writ of restitution, meaning you're asking the court to kick them out. But it's a much more in-depth process.
Yeah.
It takes a longer and costs more money
Wow.
because it's a formal eviction. It's the whole process. So you have to do that. You have to go through it. Now, and you get the order, and then they'll be evicted in the end, just like a summary eviction. The constable will come and kick them out. If they have tenants, it's a whole different process. They get a lot more protections. So with a tenant, you're still using the formal eviction process, but now you have to give them 60 days before. And if they have a valid lease agreement, meaning let's say they were friends with the owner and they signed a brand new lease agreement like a month before it's foreclosed on for 1 year. Well, you are now bound by that lease agreement.
Wow.
So you can't evict them as long as they're making payments and as long
Yeah.
as they don't violate the terms of that lease. You can't evict them until that lease is up, and then you can. So that's where the cash for keys comes in. You can come and say, "Hey, we're going to give you $10,000 to get the heck out of the house by next month."
Yeah.
Because in the meantime, now you're just sitting on this carrying it. So there's the risk that if someone's in there and they're a tenant and they have a valid lease, you're stuck.
Yeah.
You're not. There's nothing you can do. You can continue to lease it out. I know that there are other buyers of foreclosures that do that in town, that will lease these properties for just ages and not put any money into them until they're basically worn down to nothing and then sell them off.
Wow.
But that needs to be taken into consideration. That not only the condition, but the fact that if there is a tenant in there, you're not going to be able to evict them until
Yeah.
they screw up that lease agreement.
I do have 3 questions from people because I did put on my Instagram story. I was like, hey, I'm gonna record with our attorney.
Oh,
so,
I was like, okay, I thought this wasn't live.
no. So I was like,
Before we go into
Yeah, yeah.
those, so can say there's a bunch of liens from Republic Services or whatever trash company kind of force a home into foreclosure, or like a bunch of credit
Sure.
card debt?
So what will happen with Republic Services is if there's a lot of liens, there's a law firm out here, and this law firm, 99% of their work is just Republic Services lawsuits. Now,
Wow.
this was in the news actually about 8 months ago, because Republic Services chooses to publish liens over and over again. So you'll have like 15 liens from Republic Services. And each time they do this, they're statutorily, by code, they can get a certain amount of money just for putting the liens up, like $240 per
Yeah.
lien.
Wow.
They don't have to do that. One lien is sufficient, but they
Yeah.
do that just to get extra money. But yes, if you don't pay your trash bill, Republic Services, the Assembly in the state of Nevada came together and gave them what's called a super priority loan or lien against your property. So they can sue you based on the super priority lien. They can come and say, okay, you haven't paid us, so now we're going to take your house. So they will get a judgment, which then they will be able to judicially foreclose on. So before we were talking about a non-judicial foreclosure. That's where you go. You can see them advertised in Nevada Legal News. You go to their parking lot, and then you bid on the property. And with a judicial foreclosure, a little different. It's run by the court, and you go to the steps of the courthouse, and you've seen those before, and you have they sell, and you have the bidders, and same thing. Other than that, you buy the house just from the court, not from Nevada Legal News. But yes, they can take the house just like anything else. Now,
Wow.
in this instance, let's say you owe $5,000 and the house sells for $57,000. If there's nobody below Republic, because Republic is going to be below your main loan because they came later. So if there's no one below them, the excess of that money can go back to you. So you'll lose the house. You'll be kicked out. You'll be evicted by whoever buys it. But let's say you only owed them $5,000 and the house sold for $57,000. Well, $52,000, then you go back to Republic Services and they're going to give you a check for that money. So it gives you a little bit of money to start over. But if you had $300,000 equity, you've lost it. So that's the same thing with HOA sales, which is another thing we haven't talked about. A lot of times HOAs can sell your house if you owe them money, if you don't pay your HOA dues.
Yeah.
And a lot of times those dues are not much money. So the house will sell for $100,000, let's say for a $400,000 house.
Yeah.
And you are entitled to get the remainder of that money due as long as there are no lenders below them. So if they have HOA liens and there's nobody that has a lien below that or newer than that, then the rest of the money goes back to you. Otherwise, it would go to pay off the other people with liens first and then go back to you.
Is there a certain threshold as far as like time or a certain amount that it has to reach to, or is it?
No, that's why with a foreclosure on a mortgage, it's going to pay off the mortgage because they're going to make sure the minimum bid, the credit bid, will be what they're owed. If nobody buys, if nobody bids, then the house transfers back to the mortgage company, the bank, or whoever owns it. So you don't own the house anymore. At that point, the bank will own the house, and then the bank can choose to evict you or sell the house or do nothing. A lot of times banks will sit on it for 5-6 years and you can just live scot-free in a house. You haven't paid. And for, back in like the coronavirus, it lasted even longer. If it does sell and there are liens, the excess will go to you. There is no minimum. So to answer your question, theoretically your house can sell for $4,000 at an HOA sale. That person just got the deal of the century. Theoretically, if there's no mortgage, even better, if the house is like owned free and clear, it's you that loses all your equity. So, I mean, that never happens nowadays because nowadays, you still see houses going for 100, 150 at HOA sales all the time. But usually there's a mortgage that survives because it comes before the HOA.
So they have HOA sales. Where's this at? Where's this located? Where can we find them?
I believe they're done via the same as a regular foreclosure through Nevada Legal News. Yeah.
Okay, gotcha.
But don't quote me on that. I'm not 100% certain. But yeah, so those are out there. But getting way back to this. So yeah, you have Nevada Legal News is a great resource.
Okay.
And then they have a website you can sign up for, as well as you can sign up for the actual newspaper. And then there's the MLS for probates and everything.
Yeah.
Now, probates, again, are not like foreclosures. They're just regular sales that, it's going to take 6 to 9 months. But because of that, a lot of times you can get discounts. So if the house is worth $350 and they want, let's say they want 50% down, or they want a cash payment, or even if they want a regular term with 30-year fixed, but they know it's going to take 6 months to even get to a court hearing because the court has to approve it. There's not many buyers out there that are willing to wait that long. So you can realistically pick up at a little slight discount. But in a probate, there can be what's called overbidders, just like an auction, but this time the auction's in the courtroom, in the probate court. So if you think, wow, I bought this house, it's I put my offer in, they accepted the offer at $100,000 on a $400,000 house. Well, they have to publish the notice of that sale, just like in Nevada Legal News, just like the published notice of foreclosures.
Okay.
So everyone can see that, and they can look and say, wait a second, there's a sale coming up at $100,000 for this house in probate, and they'll look it up and they'll say, okay, well, I'm going to show up in court and I'm going to overbid and I'm going to try and take it from you.
Okay.
So going back, in Nevada Legal News, there will be publications for what's called the Notice of Hearing on Return of Sale.
Okay.
And that means that there's already a sale pending. So someone's already signed a contract to buy the house, but it hasn't been approved by the court yet. So you can look through those and you can see if there's any kind of crazy weird deals. But just know that there's probably a reason that someone's paying way less than appraised value, or maybe the house is just trashed on the inside. Maybe there's an issue with title or deed. But theoretically, you could show up and overbid. Yeah.
Just go to that hearing. And
Well, you have to sign up first, just like with Nevada
Okay.
Legal News. You have
Gotcha.
to sign up with the court as a registered overbidder, and then you can go to court and overbid if you want in $5,000 increments. And the judge acts like an auctioneer.
Interesting.
Not a very good one, but they try.
This is interesting. I'm super intrigued now. I want to learn that process.
Yeah.
Oh, wait. Okay. So sorry. Before we end, I wanted to know. Okay. So my friend Cece said What is something helpful for an average homeowner to know about real estate law? Someone who just owns a house and anything she should know about?
I would say maybe that homestead, but
Well, I mean, that's always good. Yeah, you want to,
Okay.
again, it's a one-page document. You can get it from the county recorder. You can go down there yourself. It's
Okay.
a $40 fee to file, and you do it, and it'll protect you. You know, one of the biggest things I would say is that when you're buying a house, especially in an HOA community, this is probably the biggest complaint that we get all the time is it's like a marriage. If you buy a house within an HOA community, and most new houses are HOA now, you're marrying that HOA.
Yeah.
And just like, you know, regular marriages, you can have a good marriage, you can have a bad marriage, you can have one that, you know, you tolerate each other. But whatever, you want to make sure that you read, you're going to get what's called the CIC disclosures through escrow when you're buying a house. It's common interest community. And in those disclosures, you're going to have the CC&Rs, the code, covenants, and
Yes.
restrictions, as well as the operating agreement for that HOA. And you're going to see what you can and can't do officially. Now, whether or not that's enforced varies per HOA. But you're also going to see how you replace the board of directors, how you can try and change policies or procedures. And if you look at this and go, what? No parking on the street? What? No parties after 10 p.m. without previous permission of like 3 different neighbors? I can't paint my house orange. You know, you need to know this before you buy in because you're stuck with it. You can't.
Yeah.
The HOA will win if they want to start fining you for violations. There are limitations under Nevada law, but you're probably going to lose. And the downside is that the cost to fight them is going to be more in most cases, way more than the cost just to pay the fees. So again, and his job, they're going to turn like the sink on and off. They're going to open the fridge. They're going to turn they're going to basically say, hey, this works. I didn't see. I looked around. I didn't see leak. They're not going to move that. You know?
Yeah.
They're not going to move the fridge and look behind it to see if the thing's leaking or if there's rot or if there's mold. You know, what is visually apparent, they will report on, but they're not going to dig into it. And that's where you get other inspectors. So I would say at a minimum, roofing, sewer, and your main inspector. If there's a pool system that looks kind of old, I'd also have a pool HVAC, or not HVAC, but a pool guy come out. Same thing with HVAC.
Okay.
If it's older, most heating air conditioning systems in Vegas last 11 to 15 years because we use them a lot.
Yeah.
Whereas, you know, other states, they can last 20, 25. So just know that if you have a system that you're buying a house on that's 10 years old or more, and it works, wonderful, but plan into your budget that you're probably going to be spending $15,000 to replace it sooner than later.
Yeah.
Same thing with pool pump, pool filter, pool heater if you have one. You want to have those inspected because, you know, you're like, wow, this pool looks amazing. Well, yeah, but it's going to cost you $20,000 to redo everything later on.
Yeah.
So just like buying a used car, you know, you want to make sure you know what you're getting into. So all the inspections, very important. Know, you know, what you're getting as far as HOA and your neighborhood. And then you want to, you know, I always recommend it, but you go through escrow. You don't want to just, you know, do a quick claim deed from somebody and just take all their problems. If you go through escrow, you get what's called title insurance. And title insurance, you know, basically says, hey, if there's something that comes up later on where somebody else is claiming a better title than you, saying, hey, that person never owned the house or that person gave it to me first, well, title insurance is going to cover you. They're going to pay for your attorneys. And if they lose, they're going to pay you back what you paid for the house. So that would be those 4 things would basically solve 80% of all the problems of buying a house.
Okay. That's good. Also, my friend Aura wanted to know life insurance, will, trust, can it be DIY or do you need a lawyer?
Life insurance, well, you can't, I mean, you can self-insure. Is that what they're talking about? Or you can buy like life insurance.
Yeah. I
But-
guess with
so-
the will and trust,
Okay.
can that be DIY or do you have to hire an attorney?
Can you basically DIY your own will and trust?
Yeah.
You can, but if you screw up, it's not going to be valid.
I
Yeah.
would recommend that.
I wouldn't.
So there's elements of it, you know, when you sign, you're going to be notarizing and signing like 15 different documents,
Yeah.
including your will. And then on top of that, we fund it, which means we have to draft a deed transferring the house from you to you as the trustee. That has to be recorded with the Clark County Recorder. If you don't fund a trust, you can have this beautiful trust, but if the
Yeah.
house isn't part of it, you're still probating the house.
Yeah.
So I would not recommend doing it yourself.
Yeah.
But I mean, it's definitely possible. There
Those-
are companies out there like LegalZoom or
Yeah.
that will prepare a trust for you. They're not lawyers, and I've looked at a lot of these, and there's a lot of problems with them.
I bet.
But I mean, if you have one house and you're able to get it recorded, and the trust might work, you might save some money, and that's the reason people do it. Our office, we have a standard fee of around $2,500 for like the whole package.
Yeah.
Not including the deeds and everything recorded, but you might be able to go to LegalZoom for $125 and get the documents. You fill in the blanks yourself, and,
Yeah.
and that's it. So I understand why people do it, but and it might work, but there's a problem where it might not. And also just to cover this on life insurance, not the DIY part, but with life insurance and or with like a bank account, you can also choose to keep those. Those don't need to be probated as long as you have a beneficiary. So let's say you have life insurance, you have an IRA, 401k, and you got bank accounts, but no house, you rent. And let's say, no car, or you're about to give your car away, so it doesn't matter. And at that point, you might not even need a will or a trust, because the beneficiaries listed on each of those accounts will take first place. So unless those accounts are made part of the trust, just like a house, meaning you go to those accounts, to go to the bank, and you change the ownership of the bank from you to you as trustee of the trust, everything will stay out of that trust. So if you have a bank account that goes to one person and your life insurance goes to another person, that will happen, and you don't need to probate it. So you won't need a trust really to officiate the transfer. It'll happen without that. But if you have an account with no beneficiary on it, then you have to probate it. And if it goes to the trust, then all the language on who gets what then refers back to the trust. So I tell people it's easier if you're doing a trust anyway to put all of the accounts into the name of the trust, because who's coming after you then, everything's right in one place. They don't have to go fishing around, go to this bank, go to that bank, prove that that this person exists or doesn't exist, or say that, hey, talking to someone else who might be grieving and say, hey, you got to go to that bank now and sign these paperwork. It's just easier to put everything in a trust. And if you're creating one, great. If you're not creating a trust, then you can let everything go straight through the bank or the investment accounts, and it'll work as long as you have a beneficiary.
Last question from Kaylee. How to structure titles and trust investments. So example, should he have one LLC for the title for the property and then one LLC for like the cash flow, I guess, like for the rent? So should he have two separate LLCs or one?
No. So it doesn't. I mean, you could do that, but you're really complicating things. You have what we usually set up is one LLC or series LLC per property.
Okay.
And the cash flow from that, like we talked about with dividends to you, you don't want to be able to transfer from one LLC to another. You don't want to be able to transfer from one LLC to you without having a full-on distribution. And and you're going to have tax records of that distribution, and however it is. I don't do taxes, so I'm not super versed in that. But the same thing is, if you have profits streaming out of one house as rental incomes, that profit needs to stay in that same LLC. So it wouldn't go to a subsequent LLC. That would basically be saying that these two LLCs are now the same company. And so it opens up the door to where if you have liability in the first LLC, but the profit keeps flowing to a second LLC, they're saying, well, wait a second, we're just following the profit river. That's the same LLC. That's the profit that should be staying in this. We should be able to track that one.
Okay.
So I don't see any real benefit to that.
Okay.
I mean, again, maybe there's a tax benefit. I don't know. But as far as liability concerns, no, it's very breachable at that point. So no, all the profit from one house stays in one LLC. And then, you make distributions to yourself or to another LLC if you want. Doesn't matter at that point, but you make the distributions. You don't just have cash flow going to a separate LLC that just is like a bank account.
Okay.
It doesn't work that way.
All right.
Cool.
Thank you again for being on our podcast. We appreciate you dropping all this knowledge and gems on real estate law. So if anyone wants to get a hold of you or reach out to you, how can they find you?
So you can go, we're on the website. It's Dresslove Law. Dress like she's wearing a dress. Love like you love Gina and Scott. And so Dresslove Law. www.dresslovelaw.com. The other side of it is Bone Law Firm. That's Bone with the BOHN lawfirm.com. And where you can give us a call at 702-814-1000.
No Instagram, no TikTok.
Oh God, no. We're already so busy as it is.
Yeah.
We don't have time for that.
Yeah.
So
okay.
But we'd be happy to talk to you.
All right. Thank you so much again.
Thank you. Appreciate it.
No problem, guys.
So if you enjoyed today's podcast, Please like, subscribe, and share.
Peace.